My sincere gratitude to the Montana chapter of the Black Law Students Association and the Innocence Project for inviting me to this 8th annual rally for the wrongfully convicted. My name is Moses Okeyo. I'm a stranger in this strange land. I'm a teller of stories. I tell stories about the strangers, the underclass, the outcast. I make them three-dimensional so you can see them. I'm an optimist. As a public defender, we routinely march into hell with the clients to persuade the devil, the principalities, and the powers holding them to loose their shackles. Just this month, the Montana Supreme Court overturned a life sentence in State v. Tom 2021 MT 229, and hopefully the DNA evidence will prove his innocence. Khalif Broder was a black youth from the Bronx, New York. Khalif was held at Rikers Island without trial between 2010 and 2013 for allegedly stealing a backpack. Khalif was coming home from a party. He thought police stopped him for a routine stop and frisk like they had done many times before. Someone had told police, "Two male guys, they took my brother's book bag." Police searched Khalif and didn't find the backpack. Khalif was held on a $3,000 bond. His family couldn't raise the $900 down needed to post bail. Despite this unbearable pressure, Khalif would not plead guilty to something he did not do. He remained in solitary confinement for 2 years. The state's case had disintegrated, yet the state kept requesting continuance after continuance after continuance while Khalif languished in solitary confinement. Because of the psychological torture of those 2 years in solitary confinement, 2 years after his release, he hanged himself in his parents' home. Jay-Z and Harvey Weinstein made a documentary miniseries titled Time, the Khalif Broder story. It's still available on Netflix. The National Registry of Exonerations say 13 to 16% of all exonerees pleaded guilty, although they were innocent. In 2020 alone, 29 of the exonerees had pleaded guilty, though they were innocent. Why does an innocent person plead guilty to a crime they did not commit? We know Article 3, Section 2 of the U.S. Constitution states, "The trial of all crimes, except in cases of impeachment, shall be by jury." The Sixth Amendment also guarantees the right to an impartial jury. But the right to trial is a choice in name only. Now, plea bargain is not in the Constitution, but it has become a major factor that contributes to mass incarceration. By plea bargaining, we mean an informal negotiation between the prosecutor and the defense to resolve a criminal case without trial. Of course, the judge must accept the plea. And some of the pleas include charge bargain or sentence bargain or both. Plea bargaining is a system of backroom deals behind closed doors where liberty is the currency. The defendants can cheaply sell their fundamental right to a jury trial in exchange for a lower charge or sentence. The prosecution and defense haggle over guilt and innocence in the prosecutor's office, and the judge simply rubber stamps the agreement in an empty courtroom. Efficient and expedient. It is also amoral, law without ethics. But all actors in the justice system turn a blind eye to all the subtle arm twisting that takes place in the prosecutor's office outside the courtroom. Under this system of pleas, innocent people regularly confess to crimes they did not commit because of inherent coercion. Sometimes the plea is set before the defense has a chance to weigh any evidence, some of which may exculpate the defendant. Sometimes harsh interrogation tactics by police. Sometimes there is emotional and financial exhaustion. Sometimes youth and feeble-mindedness of the defendant makes them susceptible. And usually there is a desire to end the whole ordeal. My point is, plea bargaining is inherently coercive. A defendant feels an intolerable pressure designed to induce them to waive their fundamental rights to a trial. Plea bargaining is an essential lubricant in the justice system. Recently, in R.V. Anthony Cook, the Supreme Court of Canada described the plea agreements as vitally important to the well-being of our criminal justice system, without which the justice system would eventually collapse under its own weight. The United States Supreme Court also readily recognized in Lafler v. Cooper, we now have a system of pleas, not a system of trials. 97% of federal convictions are achieved by plea bargaining. 94% of all state convictions are achieved through plea bargaining. The defense attorney's role is now reduced to negotiating pleas instead of putting the state's evidence to the test. Only 3 to 5% of defendants actually go to trial. Guilty pleas have replaced jury trials. An accused person who chooses to go to trial gets exponentially higher sentences if they go to trial and lose, which is roughly 3 times stiffer. This is the so-called trial penalty, or the trial tax, which is the substantial difference between the sentence offered in the plea compared to the stiffer sentence a defendant actually receives when they lose a trial. The prosecutors wield the threat of a lengthy sentence, and the fiction we peddle is that plea bargaining is a win-win solution. In essence, a quid pro quo, a give or take, that the accused is exercising a voluntary and knowing choice after being informed of all the consequences of that choice. So everyone wins, unless you're innocently accused and you are an innocent who's induced into pleading guilty. Many guilty pleas are not voluntary. The truth is, there's a massive power imbalance. The prosecutor wields broad and unrestricted power beyond their competence. I am Khalif Broder. We are Khalif Broder. In 2010, before law school, when I lived in Helena, one Friday night, I was at one of those watering holes. 6 officers walked in and they spied a black man near the front bar. Come with us. A white guy just got beat up by a black man. Naturally, I was the culprit. I almost got beat down and an arrest. I could have been arrested and charged with aggravated assault, punishable by up to 20 years in prison and a fine of $50,000. If after staying in jail for 2 years, they offered me 5 years all suspended, and like Khalif, I would probably cop a plea. I'm not as long-suffering as Khalif. The plea bargaining system is problematic even if someone is guilty. I will preface this next story by saying I'm not oblivious to the tense climate around Missoula and the law school concerning sexual assault and sexual violence. At the risk of sounding insensitive, Jason Lanua's stories about injustice and about our shared mutual dignity and humanity. It's also about a brute expression of power in our beloved Missoula. In 2017, Missoula County charged Jason Lanua with sexual intercourse without consent, punishable by 100 years to life in prison. Burglary, punishable by up to 20 years in prison. The total possible sentence was life plus 20 and possible 100,000 in fines. In Canada, the maximum sentence for any sexual assault is 10 years. Jason thought he would take responsibility for his actions. Maybe his black mother taught him to always tell the truth to authorities. He cut to the chase, represented himself, dealt directly with the prosecutor. Jason thought he would come clean and explain he went to his exes, they both got drunk, then they had sex. The prosecutor talked him into an open plea agreement. Jason was unrepresented by counsel. The prosecutor recommended 15 years with 5 suspended and only $325 in fines. Open pleas are not binding on the judge. The judge can impose any legal sentence. The trap was set. Ambush in broad daylight. When the judge pronounced 70 years, Jason realized he would spend the rest of his life in a cage. He broke out in expletives at the judge, expletives at the system that sprung this trap. At sentencing, he tried to withdraw his guilty plea through counsel, to no avail. Later, the Sentence Review Division reduced Jason's 70-year sentence to 50 years, a tacit recognition that the going rate for other white defendants in the same situation was probably much lower than what Jason received. Baiting an unrepresented 21-year-old so he can spend the rest of his life in jail is technically legal, but shows law without ethics, and it should make your blood boil. I think we are too socialized, too well adjusted not to see injustice as it's happening in our community. I am angry. You should be angry. Anger has a long history of bringing about change. Maybe our collective anger can help us start to change our culture.